Judge Eileen Cannon just ruled against Donald Trump and his interest in Florida, allowing the release, finally, of Volume 1 of Special Counsel Jack Smith's final report to the American people, allowing it to be released by midnight tonight, finding that the D.C. election interference case that's discussed in Volume 1 does not concern her case about Mar-a-Lago and the classified documents case, nor the two remaining defendants in the case, Walt Nauta or Carlos de Oliveira. New order just in, denying the emergency motion as to Volume 1 of the special counsel's report. And she sets up a briefing schedule, however, about Volume 2, about the Mar-a-Lago case, and whether it's ever going to see the light of day or whether it's ever going to go up to Congress or not, as Merrick Garland has proposed. Michael Popok here on MeidasTouch Network and Legal AF. This is a fast-moving and late-breaking story. I just did an update on the what happened over the weekend with the various filings required by Judge Cannon, in which the special counsel's office and the U.S. Attorney's Office and the Department of Justice looked her in the eye and said that Volume 1 has no impact on or relationship to anything in the Mar-a-Lago case. In other words, you don't have jurisdiction over Volume 1. That's Judge Chutkan, and that's over in the D.C. election interference world. The judge asked the lawyers to certify as officers of the court for the Department of Justice that there was nothing substantive or substantial that was in Volume 2, that was in Volume 1 concerning the D.C. election interference case that would back up on the Mar-a-Lago case. And they said under oath that there was none. Now, of course, Judge Cannon can't let well enough alone, so she dropped a footnote. I'm going to read to you from the order here. But she said her entire basis to now allow Volume 1, D.C. election interference case, final report, 500, 800, 1,000 pages, whatever it's going to be finally released by Merrick Garland midnight tonight, she based it on the representation made by the U.S. Attorney's Office that there's nothing in that backs up on the Mar-a-Lago case. But she has to chastise the Department of Justice before they even did anything wrong. Here's what she said in footnote 2. To the extent that counsel for the United States, that's the Department of Justice people, has any doubt about the representations made to this court regarding the absence of any substantive connection between Volume 1 and the factual and legal issues in this case, speak now or forever hold your peace. Reminding them that they're officers of the court, and she will throw the book at them if they lied to her, as if their natural inclination is to lie to Judge Cannon. I mean, that's where she starts from. That kind of jaundiced view, deficit lens analysis, which always drives me crazy. But the good news is what I started with. Here, let me read to you from the order allowing the release finally of Volume 1, setting up a briefing schedule relatively quickly and all before the inauguration. Again, if Donald Trump thought he was going to do a victory lap, figure out ways to spend his $200 million inauguration fund from all his donors, forget it. He's going to be in court again on the 16th and 17th for hearings if he wants to be about this particular issue. And if she rules against him, then we'll talk about what happens to the Mar-a-Lago volume of the special counsel report in a minute. But let me just read to you, because I think there's power in language and the expressed language of this order. This cause came before the court upon the emergency motion to preclude the government from issuing a purported special counsel's report contravening this court's dismissal order, et cetera, et cetera. Although it was brought, this is me talking, Popok talking now, although it was brought by Nauta and de Oliveira, come on, it was written by and puppet mastered by Donald Trump. Donald Trump's paying for the lawyers for these two. They don't do a darn thing, their lawyers, without consulting with Todd Blanche and Donald Trump. All right. So let's just call that. Let's just pull the window back, the shade back from that. Okay. The emergency motion seeks to enjoin the release of the entirety of the final report. The judge continues, as described by the United States in subsequent filings, Volume 1 of the final report concerns the election interference case as to President-elect Trump in the District Court for the District of Columbia. That's the Chutkan case. Volume 2 concerns this case, the classified documents case, which is the subject of an appeal. The United States opposes any restriction on the release of Volume 1, agrees that Volume 2 should not be released to the public while there's still a criminal proceeding against those other two guys, but nevertheless seeks permission to make a limited release of Volume 2 to the ranking members of Congress for the Judiciary Committee, which is actually required by law, which, of course, Judge Cannon completely ignores. Here's her ruling. 1, the emergency this is on page 2. The emergency motion is denied as to Volume 1, meaning Nauta and de Oliveira as proxies for Trump lose. Volume 1, she is lifting. It's going to expire at midnight tonight, her original order, and she has denied extending that motion or that order at all. The United States, so we're on the clock, right? We're on the clock. In less than 11 hours, this report should be released to the public. The United States represents that it believes that, quote, nothing in Volume 1 of the final report directly or indirectly relies, or bears in any respect upon the evidence relevant to any of the charges alleged against Nauta and de Oliveira. The United States further indicates, she says in her order, in the same filing, and reiterates in a sealed addendum, portions of which are properly revealed herein, that Volume 1 makes 2 generalized references to this criminal case, but nothing substantive. Based on these representations, Judge Cannon says the court sees an insufficient basis to grant emergency injunctive relief as to Volume 1 about the D.C. election interference case. And then she has to defend herself on jurisdiction, because nobody outside her courtroom in her head believes that she has jurisdiction to continue to issue orders in the case while the case is up on appeal. She dismissed the indictment. And the Department of Justice dismissed Donald Trump. The only thing is left is at the 11th Circuit, and they haven't ruled yet. Note to the 11th Circuit, what are you waiting for? Rule on the issue of whether Judge Cannon was right or wrong, thumbs up or thumbs down, to dismiss the indictment because she found the special counsel to be unconstitutionally appointed and unconstitutionally funded, right or wrong. Time to go, folks. However, that's up there. While that's up there, I mean, every appellate lawyer worth his salt will tell you the jurisdiction of the trial judge is divested at the time it goes up on appeal. She has no power to do what she's done. She says she does, because if a case ever comes back to her, she has to make sure she protects and make sure that the two defendants aren't prejudiced. I think that's the role of the appellate court. And the appellate court, if they wanted to issue an injunction or a stay, they could have done it. But of course, we often disagree with Judge Cannon. So then she says she has the jurisdiction to do these things. Then she turns to Volume 2 on page 3, which is Mar-a-Lago, her case. She says the emergency motion as to Volume 2 presents factual and legal issues that are contested that must be resolved in an orderly, expedited basis following full briefing and a hearing. So when I first heard that, I said, oh, this is going to be sometime after Trump is inaugurated. No, she surprised me. Once again, sort of stuck at the Trump here a little bit. Despite these concerns about prejudice, she says that the United States, the Department of Justice, seeks permission to make a limited disclosure to congressional leadership, citing public interest in keeping congressional leadership apprised of a significant matter within the department while safeguarding defendants' interests. I think she's misreading the special counsel rule and law and what is required by the Attorney General to turn over and report to the leadership of the Judiciary Committee, House and Senate. It's not like they feel like doing it. They're required to do it. She always misses the boat on these things. So she says, in light of these concerns, she's scheduling a hearing January 17th at 2 p.m. in Fort Pierce, Florida. And she wants the following briefing schedule. She wants the government's response to be filed by the 14th of January, tomorrow. By tomorrow, she wants the government's brief in opposition. And if there's going to be any reply, she wants that by Wednesday. Then she's going to hold the hearing on Thursday. So by Thursday this week, we're going to have Judge Cannon's decision about whether she's going to continue to try to block the release of Volume 2 about Mar-a-Lago, not to the public, because Merrick Garland took that off the table already, but to Congress. Now, maybe between now and then, Congress should intervene. Attention, Jamie Raskin. Attention, Dick Durbin. Maybe it's time for you to intervene as members of Congress and kind of teach the judge about the special counsel law. I would encourage that. We should pick up the bat phone and let Jamie Raskin know that, along with Dick Durbin, if they don't already know that. They should intervene. Donald Trump may not like this either. He could try to take an appeal to the 11th Circuit, but the 11th Circuit is already sitting on an appeal about her underlying order about whether she has jurisdiction to do this at all. And they haven't ruled. So we're going to see a couple of things happen over the next 48 hours. Could even be starting today after this hot take. 11th Circuit may wake up and decide they're going to rule on the similar issues up on appeal when Jack Smith's office through the Department of Justice decided to appeal her original emergency motion and that she didn't have jurisdiction. If they rule on that, rip up all of these orders and we'll get this thing released tonight as planned. They may just sit on it and let the midnight come about. Department of Justice, by the time we wake up tomorrow on Tuesday, we got the report. Give me a minute, along with the rest of the Meidas Mighty and legal AFers to go through it. It's probably going to be 1,000 pages, but then we'll report on it. While she sets up this briefing schedule, which the 11th Circuit could still look at and go, no, I don't want a briefing schedule from you. We're taking away your jurisdiction. You are done, based on this appeal that's up at the 11th Circuit. The problem is the timing of these things. We're trying to get all this done before the 20th. We're running out of time. I mean, Donald Trump's inaugurated a week from today, okay? A week from today, it's hard to believe he's being inaugurated as president of the United States again. The only thing I got going for me is that when Hail to the Chief is played at the very beginning, it's because President Biden is still the president. And when it's played at the end, it's because Trump is walking out as president. I mean, that's our transition process. That's what the voters and those that wanted to stay home from our democracy in November, this is what they wanted. We'll continue to follow it all. So let me give you the summary, the talking points. Judge Cannon has ruled in effect against Donald Trump. Volume 1 is going to come out by her order. She is vacating that portion of her emergency order that would have blocked the continued release to the public of Volume 1. Merrick Garland has already said he's releasing Volume 1 about the D.C. election interference case to the public as soon as he can, as soon as Judge Cannon or the 11th Circuit tells him it's okay. So I think that all the witching hour for that is going to be midnight tonight or soon or early in the morning. That's one on Volume 1. On Volume 2, Judge Cannon wants to have a whole hearing and full briefing all this week in the next 72 hours before she'll even allow, if she thinks she has the jurisdiction or the power, which I don't think she has, if she's going to even allow the Attorney General to release that volume to the congressional leadership. Again, I've always said I don't think we're ever going to see Volume 2. I had a debate with Ben over the weekend on that. I don't think we're ever going to see that Volume 2 unless some intrepid media organization like the MeidasTouch Network does some sort of FOIA or other public records request, and maybe we can get our hands on it once Donald Trump pardons the two co-conspirators. So we'll have a quick and dirty evidentiary hearing, emphasis on the dirty this week with Judge Cannon. The 11th Circuit is still sitting on an overriding issue, which could take the case away from Judge Cannon at any moment and take it back to the 11th Circuit. While if I'm Merrick Garland, there's some tips. If I'm Merrick Garland, get that report out now before it gets blocked again by somebody. Don't wait another minute. At 12:01 a.m., get that report out. And if I'm Jamie Raskin and Dick Durbin, I try to intervene and try to teach Judge Cannon a lesson about the role and power of Congress and the separation of powers. That's what I would do. You're here on Legal AF and on the MeidasTouch Network. You know how to follow us. Wednesdays and Saturdays, Legal AF, the YouTube channel, and for our podcast. Popok Live, Tuesday nights at 8 p.m. Eastern Time. A longer version of what I just did now with more topics. Okay. And then Legal AF, the YouTube channel. We're already hit 400,000 subscribers at our 4-month birthday, all because of you. So until my next reporting, this is Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.